My name is Chu Machinye, and I am your family lawyer. What then are the consequences of a successful legal challenge of an application for probate? If the court upholds a challenge, the probate may be revoked if already granted. Then a new executor or administrator may be appointed. The estate distribution, of course, would naturally be suspended until the issues are resolved. Unfortunately, the estate may fall into intestacy. This may significantly delay the administration and increase the legal costs of administering the estate. Where a will is successfully challenged, the will will be declared invalid. The estate is then administered under intestacy laws. The wishes of the testator are rendered nugatory, useless. Beneficiaries under the invalid will lose their inheritance. In some cases, an earlier valid will may be revived, but in most cases, what happens when this will is set aside is that the estate now falls into what is called intestacy. It is as if the man or woman never made a will, and the applicable laws of intestacy for inheritance would then apply to that estate. Where, for instance, the deceased was married under the Marriage Act, the laws governing that would apply, and the order of inheritance most likely will be his wife, children, parents, and then before the siblings. But when he died without or being married under customary law would apply depending on where he comes from. Like is customary in this podcast, we will now try to apply the law to facts. It is time to connect these legal principles and jargons that I've been struggling to explain to you to the lessons that were learned by others in the courtrooms. And my prayer is that you wouldn't need to go through the courtrooms to learn those lessons, and that their stories should help you avoid the pitfalls that took them to the courtroom in the first place. Let's look at a case that was decided in 2019 by the Supreme Court of Nigeria. It addressed the question of the validity of a will that was purportedly made by Madam Adeline Kasumu, who passed away in 1955. Just look at the timeline between 1955 and the time the case was decided. The background facts are as follows. The central dispute actually revolved around the property that was located at number 19 Igbo Shere Road in central Lagos. It was registered in the name of Madam Adeline Kasumu, but her grandchildren, through her son, Adetokunbo Kasumu, claimed joint ownership of the property, asserting that it was family property. Conversely, another relation claimed, who was a grandchild of the deceased, also claimed exclusive ownership based on a will that was allegedly executed by Madam Kasumu, which purportedly bequeathed the property solely to her daughter, Mrs. Roslyn Adeola Bruce, who was the mother of this grandchild that was claiming exclusivity. If her claim stood, Mr. Adetokunbo Kasumu will be disinherited. The issues the court had to determine included whether the will fulfilled the conditions set out for validity under Section 4 of the Wills Law of Lagos State. And secondly, the court had to determine who had the burden of proving the validity of the will, whether it was the person who claimed sole ownership or the other individuals who thought it was family property. This matter went all the way to the Supreme Court. The Supreme Court held that the will must be in writing, it must be signed by the testator, and must be signed by the witnesses in the presence of the testator, and vice versa, and that the signature must be made or acknowledged by the testator in the presence of at least two witnesses contemporaneously, simultaneously. The court found that the will did not meet these requirements. Specifically, the will lacked the necessary attestation by the witnesses, thereby rendering it invalid. It was further decided that the burden of proving the validity of a will rests on the person who is asserting that the will is valid. Note this, if you are the one saying a will is good, you have to prove that it is valid. And in this case, that person failed to discharge this burden because there was insufficient evidence to establish that the will was executed in compliance with the statutory requirements. The will was therefore declared invalid due to non-compliance with mandatory provisions of the wills law. Consequently, the property in question was deemed to be family property. Let me at this point remind us to please subscribe to this podcast. And if you think that this is useful to you, please share it with other persons. If you do have a need, please place a call through the number that's on your screen right now. We'll now tell you another story that affects the question we answered you earlier as to who can apply for probate. This involved the Igbokwe family and was decided in 1994. When Chief Augustine Igbokwe, a respected Onitsha businessman, died in 1992, his family gathered traditionally to hear the reading of his will. The document named his second son and longtime family friend as executors, two of them. But tension arose when his eldest son, Emmanuel, stormed the probate registry to apply for probate himself without being named as an executor in the will. The court, of course, had to step in. And the court held that only named executors in a valid will have the legal right to apply for probate. Emmanuel was reminded that probate isn't about seniority. It's not primogeniture, which is a common native law practice in Igbo land. It's about legality. Under the probate rules and administration of estate law, only the executors named in a will can apply for probate, unless where they renounce or when they are dead. Therefore, being the firstborn doesn't mean you are the first in line to manage a will. Who manages a will is determined by the maker of that will, which is why we encourage you to make one so that your will can count. We'll also quickly tell you a story where the testamentary capacity of a maker of a will was decided upon by the court. In this case, which was decided in 2003, Pa Bankole, aged 89, wrote a will 2 weeks before he died. He left his house and farmland to a church he had only joined recently. His son challenged this will, claiming that Bankole, the old man, was senile. In court, the family doctor testified that the old man had dementia and could not recall his children's names. The court ruled that he lacked testamentary capacity, and I think I agree. For a valid will, the testator must understand what a will is. He must understand this to the extent that he knows he's giving out his properties by what he's writing and signing. The outcome of this matter was that the will was invalidated and Pa Bankole's estate fell back to intestacy. Whatever he wrote down in that will came to nothing. That is if he was the one who wrote it. Let's also talk about what happened when somebody is said to have been under undue influence. Mrs. Okelola, a widow, lived with her housekeeper who was named Boyle for over a year. When she died, a will surfaced, leaving her entire estate to his houseboy Boyle. Her nephew challenged it. Apparently, the children she didn't have or they were not there. This nephew claimed that Boyle isolated this woman, controlled access to her from friends and family, and made her change doctors. I will now talk to you about a matter, tell you a story that where undue influence was proven and the will was invalidated as a result. Mrs. Okelola, a widow, lived with her housekeeper, Mr. Boyle, for over a year. When she died, a will surfaced miraculously, leaving her entire estate to the houseboy, Boyle. Her nephew, of course, challenged that will. He claimed that Boyle had isolated his madam and controlled access to her from friends and family, and even made her change her doctors. The court found signs of undue influence. The circumstances were suspicious. The total exclusion from family and a sudden transfer of wealth to a dependent with whom she had been acquainted for just a year raised eyebrows. Eventually, the court set aside the will. Now, my final word on today's episode. Wills tell the final story of a life, but only if the wills are valid. Probate ensures the story is authentic. Executors are the narrators of this story, and the courts are the editors, making sure that the story makes legal sense. If you're writing a will, do it properly. Let your will be drafted by a competent family lawyer. If you are in doubt as to how you should begin the process, please visit our website or send us a WhatsApp message or call us on the number on your screen. If you have been named an executor, please do your job faithfully. And if you are left out unfairly or you feel you have been left out unfairly, talk to a lawyer because you might just have a case. I hope this has been impactful. Please join me next Saturday on Your Family Lawyer when we bring you an even more interesting episode. Until that time, please do not forget to click the subscribe button and turn on your notification bells for more interesting episodes. For legal consultations or advice, call us today by dialing the number on your screen or send a WhatsApp message through another number that's also on your screen. Until then, stay informed and be empowered. My name is Chuma Chinye, and I am your family lawyer.